how did I get put on child support, but I was never formally served any paperwork? One of the most asked questions that I get from clients is, how did I get put on child support, but I was never formally served any paperwork? And I think people need to understand that depending on the circumstances, a person may not have to get served via a process server or via the sheriff, right? So in Florida, the Department of Revenue can serve you in an administrative child support case via certified mail, okay? So it's not required for the Department of Revenue to serve you with the process server for every child support case. So in administrative child support cases, it's only required that they serve you via certified mail. So it's really important that you tell your loved ones or your family members that you used to live with that if anything comes for you via certified mail, to reject it if you don't live at that address. Because that's all the department needs in an administrative child support case to move forward with establishing child support. Now, there are a few things that are really important that you have to realize when you're dealing with a child support or an administrative child support case. The first thing is that you want to respond immediately. You want to talk to an attorney immediately. Most cases, people kind of bury their head in the sand. They don't, take it seriously because they don't believe that it's as important because it wasn't served via a process server. It's crucial that you take action the very first time you receive a notice from the Department of Revenue regarding an administrative child support action. Now, why is it important? It's important because there are certain deadlines that you have from the date that you receive notice initially. So, pursuant to the statute, Florida statute section 409.2563, the Department of Revenue can establish child support administratively, right? And like we said earlier, they can do so by serving you via certified mail. Now, you want to make sure that you opt out of the administrative process if you're able to. So typically when you initially receive a notice, you have the option to opt out and to request that the Department of Revenue proceed in the circuit court. Or you could also request that you want to move forward with your time sharing or establishing paternity rights in a separate action. Now, this is important because if you can't opt out, you want to do so. So if you talk to an attorney when you are initially served or when you initially receive information about the administrative child support action, it's possible for your attorney to have your child support and your time sharing rights heard in one case. So that will save you money. If you wait too long to opt out or to try to opt out of the administrative child support case, you may have to hire an attorney to represent you in the child support case. And then you might have to also hire an attorney to represent you in a paternity case, okay? So you want to make sure that either way, you have an attorney involved to help you out as you are going through this process, because there are certain things that you can't undo if you wait too long. So a lot of times, dads, most of the time, will reach out to me and say, hey, Department of Revenue established my child support arrears at $20,000. I need you to fix this. Well, at that point, it's too late for me to do anything to try to modify or fix the arrears that were assessed in the Department of Revenue administrative case. I can only help you or try to modify your child support as it relates to your ongoing support. So I'm limited in what I can do at that point. That's why I encourage anyone in Florida, especially, to make sure that you seek legal counsel as soon as you learn about the administrative child support proceedings. Again, when you get a notice, any notice from the Department of Revenue, speak to legal counsel about your rights and how you should proceed. Now, some of the pitfalls that I see are that people just ignore it, right? They ignore it and they don't respond, and they wait until they get that big number at the end for the back child support to try to talk to an attorney. So when we're calculating child support, you can get assessed arrears back from 2 years. Okay, so if you go back 2 years and you don't pay attention to what they're saying, or you don't participate in the actual proceedings, they may not give you a credit for any child support that you may have given to the mother during that time period. So it's important that you are a participant in the proceedings, that you know what's going on, and you have someone assisting you. Some of the major pitfalls that I see in administrative child support cases is that there is no due diligence done or no discovery done to verify the income of the other parent. There was no discovery or due diligence done to verify what the other parent said they were paying for daycare. And there was also, in most cases, no due diligence or any discovery done to verify with what the other parent said they're paying for healthcare. All of those factors are really important because daycare, the income for both parties, what the other parent is paying for medical or for insurance, that all plays a factor into calculating your child support, and it has a big impact on the amount of child support that you will have to pay. Also, when they're looking at your child support and they're going to go back retroactively and calculate your child support, they're going to use those numbers. So say you got a job where you're making, $30,000 more now than you were a year ago. If you aren't participating in the case, and if you aren't, able to articulate that, hey, this new job where I'm earning this amount of money started 2 months ago, but prior to that, I was unemployed, that could negatively impact your case and how much you have to pay in back child support. So again, one of the main pitfalls is to make sure that you hire counsel. Just because you're not served with a process server, just because there's no, pending court date, doesn't mean that this legal proceeding is not important, and it doesn't mean that it cannot have a negative impact on your case. Because what's going to happen is that once there's a final order, you're on the hook to pay that amount in child support, right? And if you hire an attorney at that point, then we can only go back, like I said, and modify from the date that we file your petition for paternity and your superseding order to modify child support forward. All right. And I want to make sure that I reiterate that there are like 10-day deadlines, 20-day deadlines that you will see when you read the actual letters and the notices from the Department of Revenue. So you do not have a lot of time to, follow up with an attorney, or I'm going to take care of that next week. As soon as you see it, take action now. As soon as you receive a letter from DOR, take action immediately, because it could be a matter of days, and they're very strict on the days. If you do not opt out within a certain time period, if you do not request a hearing in a certain time period, you've waived your right to do so. So do not wait, and make sure that you seek legal counsel as soon as you possibly can whenever you get a notice regarding child support. So if you have any other questions, again, please leave us a message leave a message in the comments. Make sure that you reach out to us on Facebook, YouTube. We'd love to answer your questions, and continue to like our page and to check in and see our videos, and hopefully they'll be helpful to you or someone that you love.